Produced by
Elon Musk versus OpenAI and others. Please like, share, and subscribe. I really need to start this case off with a disclaimer, this report, because this is a report on allegations made by Elon Musk in a filing at the Superior Court of California in relation to a dispute that he has with the OpenAI LP, LLC, and other companies within that group, and somebody called Samuel Altman. So I first start by saying that everything said in this report is for information purposes only. It's all alleged because a court hasn't made any findings in relation to the information that I'm going to talk about. And you should, in any event, always do your own research, and we're not going to be held liable for anything said in this report. It's just a review of material submitted on behalf of Elon Musk. I'm not going to comment on whether it's true or not. That will be for the court to do, the Superior Court of California. That will be for them to do. But the case being brought does raise some interesting issues that are applicable to anybody who has an interest in technology, intellectual property, and the advance of artificial intelligence, and I guess too artificial general intelligence. So let me start off by looking at this. So a lot of us will have become familiar with terms such as artificial intelligence, Chat GPT, GPT-3, GPT-4 over the past 2 or 3 years or so. And essentially, those are models of artificial intelligence that appear to have been developed by this company called OpenAI. And a lot of people use them, the algorithm behind them, to create all sorts of different things, from, music to books, or all sorts of different types of applications for that use of artificial intelligence, and art as well. Let's not forget art. But aside from that, there's industry and business uses, and it's something that a lot of people have come to terms with and gotten used to. Now, I'm going to be reading some excerpts from this filing. So the first thing to say is it says there's an electronic filing filed Superior Court of California, County of San Francisco, on the 29th of February 2024, Clerk of the Court by Kevin Doherty, Deputy Clerk. And the case reads, and you'll see some excerpts in the photos that are part of this report on this channel, so to speak, that it's Elon Musk, an individual. So it's Elon Musk by himself as an individual, the plaintiff. In the UK, they call them claimants, I think. And versus the following people and companies. So Samuel Altman, an individual; Gregory Botman, an individual; OpenAI Inc., a corporation; OpenAI LP, a limited partnership; OpenAI LLC, a limited liability company; OpenAI GP LLC, a limited liability company; OpenAI OpCo LLC, a limited liability company, and the list goes on. OpenAI Global LLC, a limited liability. It's the group of companies essentially. OAI Corporation LLC, limited liability. But I'm just going to say all the names just for completeness. OpenAI Holdings LLC, limited liability company, and does 1 through 100 inclusive. So there's defendants, okay? And the first page is essentially they set out a demand for a jury trial. I'm not going to go through everything, but there's a paragraph dealing with who the parties are and where they reside, etc. I'm not going to go into that. And then it goes on to jurisdiction and venue. So, as far as I understand it, that would refer to who's got authority to make a decision in this matter. And it's suggested in that paragraph 14 that many of the occurrences, representations, and events upon which this action is based took place in the county of San Francisco, state of California. And it says here where the vast majority of defendants reside or have their principal place of business, and the vast majority of the occurrences, representation, events upon which this action is based took place in the state of California. Now, there's some general allegations. Let me see. That's A, B, C. It goes back to A. All right. So the general allegations. So he's covering the risk of artificial general intelligence. So as an introduction, over the course of the 20th century, the United States gradually shifted from a primarily human labor-based economy to a primarily human knowledge-based economy with economic value increasingly created primarily by human intelligence. As the century progressed, another paradigm shift was already underway, value creation through artificial intelligence. And then it talks about in 1996, IBM's Deep Blue AI program beating Garry Kasparov, who's world champion in chess then. And he goes on to talking about the 2000s and early 2010s where there's an older algorithm called deep learning. Okay, so he's kind of introducing the topic in those paragraphs. Now, this is what's crucial to this this claim or that's been made by Mr. Musk. And I'll make a quick summary actually, just in terms of what it seems to be happening here. I'll state two main themes that seem apparent. One is that there's a concern over the strength and power of the artificial general intelligence and what it may be capable of doing in the future. That's one thing. The other main underlying part of this, it seems, is that Mr. Musk, he's alleging, and I can't say either way, but he's alleging that he provided a lot of assistance and funding to OpenAI in its starting phases, and he did so on the understanding that the research developed by OpenAI would be used for the public interest, essentially, not commercially. So he understood that he was having dealings with a non-profit organization, and that the resources and the information, everything built up would be used to benefit the public. I also get the view that he kind of wanted to keep an eye on the development of AGI, because as he's put here in the paragraph 18, that he's felt that poses a great threat to humanity. So that's kind of what his view is. The other part of it, and there's a lot more. I mean, it's how long? Many pages? I think it's a 46-page claim document, plaintiff document. Okay, but the other main element of it is that it seems that he's alleging that OpenAI went into some type of association or agreement with Microsoft, and Mr. Musk's understanding was that agreement had always been limited to AI, because from his view and understanding, AGI was never going to be something that would be commercialized, because he wanted to keep it under review, learning more about it. And what his concern is now is that the agreement with Microsoft, which includes AGI, then becomes commercialized. And what he's saying, that he believes that through some sources that they have developed AGI, and he's concerned that it's still a threat to humanity, and B, there's a lot more to it than that. This is just my layman's look at it, so to speak. But essentially, Microsoft shouldn't it's not or wasn't expected for Microsoft to be able to have the resources of this non-profit company, and therefore that is the breach of the main agreement that he understood that he had with OpenAI in its initial phases, and in doing so, there's essentially a breach of contract. That's what I understand from it, from my layman's understanding. But I'm going to read a bit through it. So I took you to the risk of artificial general intelligence. So it's overview a case, and then B, this is what I was speaking about more recently, which is this is at paragraph 23, the founding agreement, and I might provide a link to it below. Obviously, everybody make sure you like, share, and subscribe to this video, and also check out all the other videos on the channel. But the founding agreement of OpenAI. So it seems that it's a paragraph 23. Mr. Altman purported to share and bear in mind, and I say it again. These are all allegations that are being made. I can't verify the truth or not of them. This is just me reporting on what is in this document, rather than me putting anything as a particular fact or anything. It's just I'm just looking at what he's saying. I'm just seeing what his position is on this matter. But yeah, moving forward, Mr. Altman purported to share Mr. Musk's concerns over the threat posed by AGI. In 2015, Mr. Altman wrote that the development of superhuman machine intelligence, SMI, is probably the greatest threat to the continued existence of humanity. There are other threats that I think are more certain to happen, but unlikely to destroy every human in the universe in the way that SMI could. Okay. Later that same year, Mr. Altman approached Mr. Musk with a proposal that they join forces to form a non-profit AI lab that would try to catch up to Google in the race for AGI, but it would be the opposite of Google. And paragraph 24 says, this is where, Mr. Brockman, I guess is why he's been named a defendant. Together with Mr. Brockman, the three agreed that this new lab would be a non-profit developing AGI for the benefit of humanity, not for a for-profit company seeking to maximize shareholder profits. And by that, I mean, this is my inference that that's a reference to the later agreement with Microsoft. That's kind of in the actual text of the claim, kind of outlines what I was saying earlier on. I'm going to jump to C. This is at paragraph 29, the 2023 breach of the founding agreement. In 2023, defendants Mr. Allman, Mr. Brockman, and OpenAI set the founding agreement aflame. So essentially saying it set that agreement on fire. In March 2023, OpenAI released its most powerful language model yet, GPT-4. We probably a lot of us probably remember this when that came out. Is not just capable of reasoning. It is better at reasoning than average humans. It scored in the 90th percentile on the So in this paragraph 30, they go on and set out some of its achievements. Okay, that GPT-4. Now, this is very crucial now. Paragraph 31, he says, or lawyers on his behalf, furthermore, on information and belief, GPT-4 is an AI algorithm. So remember, he had this fear of the scope and potential of these types of algorithms, and hence expressly outside the scope of Microsoft's September 2020 exclusive license with OpenAI. In this regard, Microsoft's own researchers have publicly stated that allegedly, given the breadth and depth of GPT-4's capabilities, we believe that it could be reasonably be viewed as an early yet still incomplete version of the artificial general intelligence AGI system. Moreover, on information and belief, OpenAI is currently developing a model known as Q-Star that has an even stronger claim to AGI. So this is the paragraph C, the breach of the funding agreement. So we can see where we're going there. All right. So and then so this is detailed allegations. So I'm going to go through these, and not in a great level of detail now. But paragraph 84, Mr. Musk's concern over AGI falling into the wrong hands. So you can take a look through that paragraph. And B, OpenAI Inc.'s Incorporated founding agreement was. This is in paragraph 50. All right, so he's got concerns over the strength of the algorithm. He's got concerns that it's been used by another commercial organization. I have to, if I'm objective, I have to make the comment that, some people might say, I'm not saying that I hold this view, some people might say, well, okay, so Elon Musk has got Tesla, Elon Musk has got Twitter now, X.com. The latter, I mean, they're all intellectual property, they're actually intellectual property. And I would say that a lot of tech companies are in a quest for data or machines or computers that can use data to increase shareholder profits. So some people might argue, well, we understand that he had this understanding at the beginning of his agreement with OpenAI, but is this just a ploy to prevent Microsoft or any other technology companies getting even bigger and posing a commercial threat rather to any of Elon Musk's organization? That's what some people might put their tongue in cheek and say, because the tech companies are in competition with each other, aren't they? Really, that's just how it is. But obviously, he set out very detailed grounds in this report as to why, based on actually what happened at the beginning of his association with OpenAI, why he feels that they are in breach of agreements and licenses. So some people might say, okay, he's trying to protect his commercial position in the information market, but he's saying, this is you're in breach of these agreements. I gave you all these resources. I spent all the time assisting you in San Francisco, and you've just gone against it, and then you're helping out. Well, he's not saying it's a competitor of his, but he's saying that you're helping a commercial company in breach. That's the point that he's making. Okay. Now, I should say, I haven't seen the response to this. As I said, this is a document that was filed. What was that? I'm just going to go back up the page. Was it the 29th of... One second. Yeah, the leap day. The 29th of February 2024. So it's going to be a subject, I imagine, to a considerable response by the defendants concerned. So this isn't, just to be clear for anybody listening, this definitely isn't the end of this matter. Obviously, there's this, there's a number of things that can happen. They could potentially settle this. They could potentially, it might go all the way. We get to see the response from the defendants concerned, who may agree with certain points or challenge certain points. We don't know. We're yet to see that document. So let's, I'll probably do another video where we can look at how this case develops and the responses to that case. And then, at some point, may or may not, this matter may go all the way to be heard at court. I know in America, I think they do depositions or something before, where evidence is given in front of a video, and then later on they go to that evidence becomes part of the. I mean, my American listeners, you can correct me if I'm wrong on that. Later on, that evidence gets heard as part of the trial, and then people get cross-examined, etc. But he's asking for jury a jury trial on this, so that's going to be quite an interesting spectacle, so to speak. Moving on from that, what's he actually seeking? Let's see. I did take a note of that. Well, just give me a second. What is he actually seeking? What is he seeking? Well, actually, that was set out earlier. I'm going to be jumping. This is a very long document, by the way. It's 46 pages long. So I'm kind of jumping in between. Let me just see if that was in the first part. So what remedy is he seeking? All right. That might be in the... Okay. Do you know what? I'm not going to miss it at all. I'm not going to miss it. So on the first page of the case, in summary words, that is the remedies that he is seeking. So the remedies is what he is what he wants to be awarded in respect of what he says to be breaches. And what it says is, this is on the first page, complaint. So 1, breach of contract. 2, promissory estoppel. 3, breach of fiduciary. Sorry, no, that's what he's claiming. He's claiming rather, sorry, breach of contract. 2, promissory estoppel. Breach of fiduciary duty. 4, unfair competition under, I guess that's a California Business and Professional Code, maybe. Number 17200 ETSEQ, and 5, accounting and demand for jury trial. My layman's understanding. So breach of contract is just saying, look, you said this is what we were going to do, and you haven't done it. Promissory estoppel, very technical term there, but I think that's based on promises that people make that are then later relied on to their detriment, maybe something along those lines. You do your own research on that. Take a look at what promissory estoppel is. Breach of fiduciary duty, so that would be, I don't know, layman's understanding, Urban Dictionary. Somebody who has primary responsibility over an organization to act in its best interest and in keeping with its agreements, not doing so. That's what my layman's understanding of what fiduciary duty would be. Unfair competition, I think that's kind of speaks for itself. So that's probably with reference to Microsoft, maybe, in relation to how they might be able to use the software. But I could be wrong on that, actually, because it might also be a reference to any of the OpenAI group of companies and them being able to enhance their commercial position because of that AGI or the Ape AI or any of that technology against other companies in the market. I don't know. I'm not going to claim any sort of expertise in relation to that, but that's from a layman's perspective. Maybe that's what that means. Maybe do your own research, take your own, have a look at that yourself. And accounting, that must be. I mean, it doesn't say false accounting or anything like that, but accounting must be. It's going to be to do with the numbers and presenting. Well, it might be to do with actually, what I read earlier in relation to the capability of the AGI that exists. So it could be to do with numbers and presenting, making sure that they, provide disclosure of the financial figures within the company, or it could also be maybe accounting for what technology they actually have. What's actually going on? Do you have the AGI? What's its full capabilities? Have you really told, Elon must be asking, maybe you haven't told me enough, I need to know more. Maybe that's what that means. But, this is just me, layman's perspective, just looking at that, just those complaints to see. But what I did say was that I'd be looking at what he's seeking. I'm not going to spell out everything that he's seeking, but I think it was page 26. I might have to jump to I think it was page 20. 1 second, give me a second there. First cause of action, breach of contract. Second cause of action, third cause of action, breach of fiduciary duty. Fourth cause of action, unfair business practices. So he sets out all the causes of actions around just above page 33. Then relief. Okay, this is important. Are we towards the end of the document? Okay, so there's exhibits follow after page 35, but the relief. Okay, let's see what's been said here. Okay, so I did see earlier on in the document that he referred to damages above. That's it. Okay, so this is it. So I'm going to start at paragraph 135. So it says, as a direct and proximate result of defendant's breaches of fiduciary duty, plaintiff and the expressed intended third-party beneficiaries of the founding agreement have suffered damages in an amount that is presently unknown, but substantially exceeds the court's jurisdictional minimum of $35,000, and if necessary, will be proven at trial. So from that paragraph 135, I take it to mean that he feels that the damages are going to be above 35,000, which would be necessary to proceed in this court anyway. But the actual amount, I guess, is going to be assessed later on, i.e. at trial. And he also says at paragraph 136, plaintiff seeks and is entitled to specific performance of the defendant's contractual obligations as a remedy for the damages for defendant's breaches of fiduciary duty. Okay, so he's basically saying, look, this was in the agreement. You need to follow through with what that agreement said, which would include, in these terms, not allowing Microsoft to benefit from the stuff that was meant for the public. So none of the AGI stuff, and making sure that all of the research is for the public's interest, is supporting the public, not for commercial companies. So that's my layman's understanding of what probably being said here. I'm not professing to be an expert in relation to any of this whatsoever. I'm just reading and kind of analysing what I'm looking at, really. And certainly you put in your in the comments what your views are on this developing case and matter. So, and then in terms of the prayer for relief, so this is more specific terms of what he's seeking. So this is on page 34 of, it's known as a complaint. I referred to it as a claim earlier on, but it's of the complaint, but it's like the claim form, or claim, etc. Wherefore plaintiff prays for judgment against the defendants as follows. So asking for an order compelling specific performance, which I just said, of defendants' repeated contractual promises, including without limitation, an order requiring the defendants to continue to follow OpenAI's long-standing practice. And I'm going to actually read this right through, because this is essentially the crux of what's been sought here. An order requiring that defendants continue to follow OpenAI's long-standing practice of making AI research and technology developed at OpenAI available to the public, and an order prohibiting defendants from utilizing OpenAI Inc. or its assets for the financial benefit of the individual defendants, Microsoft, or any other particular person or entity. B, for a judicial determination that GPT-4 constitutes artificial general intelligence and is therefore outside of the scope of OpenAI's license to Microsoft. C, for a judicial determination that QStar and or other OpenAI next generation large language models in development constitute artificial general intelligence. I'm just going to pause there. This is going to require a lot of expert evidence on this point to present to the judge. So actually, it's going to be the jury, but then obviously maybe a judge makes a final decision. My American people, tell me how it works over there in your system. But I take it's going to take a lot of evidence to show this stuff. I mean, this is not a simple case at all. I mean, this is actually, I would say, in fact, this is probably quite a groundbreaking case where you're asking the court to determine whether we have artificial general intelligence in 2024. And this is going to be really significant. So let me just continue. I was in the middle of, I think, paragraph. So I'm in the prayer for relief, which is what has been requested and asked for. And C is what we're talking about, the judicial determination in development. Okay, so I'll read that. For a judicial determination that QStar and other OpenAI next generation large language models in development constitute artificial general intelligence and is or are outside the scope of OpenAI's license to Microsoft. I'll continue from D. Injunctive relief consistent with to effectuate items A to C above. So injunctive relief, layman's understanding, is just basically either mandatory to cause them to provide that information, the court to make the determination and the implications arising from that, and also to stop them from essentially assisting Microsoft or any other companies. Basically, that's what I'm hearing here. and to force them to only help the public. That's layman's term. That's basically what I'm understanding what's actually going on here. E. For an award of restitution and or disgorgement of any and all monies received by the defendants while they engaged in the unfair and improper practices described herein, in addition to prejudgment interest and penalties pursuant to the Business and Professions Code 1700. Okay, so that's dealing with the money. It doesn't say what the figures are, but those, as I said earlier, it seems that those will be assessed. Okay, so this was the point in relation to accounting, which I was a bit unsure about. For an accounting of funds donated by the plaintiffs and others to OpenAI, and of intellectual property or derivative works funded by the same, and of defense, so that he wants to know how the money's been spent, what those funds have been spent on, and to basically let him know more about those works and the intellectual property, and of defendants' use of the same for personal benefit. So he also wants to know who's had the benefit of those resources for personal benefit or the benefit of any individual or third-party entity. And then G, for general compensatory and punitive damages to be proven at trial, each of which the plaintiff will contribute to a non-profit or charity. Okay, so so it seems, one second, let me just make sure that I've got this right. For an award of restitution and or disgorgement. So E seems to be asking for the money spent back. I could be wrong, but that's what it seems to be seeking while they engage in the unfair. So the restitution, that's given back of the monies received. F is asking for the monies, to know how the monies have been spent. And G is suggesting that the general compensatory and punitive damages be proven at trial, each of which the plaintiff will contribute to a non-profit charity. So for the plaintiff will receive the money upon winning, and we're going to see whether that happens or not. I have no idea. Obviously, a crystal ball, but we'll see whether that happens or not. And if the plaintiff does receive it, they'll contribute to a non-profit or charity. So, I guess that's in keeping with the underlying theme for the resources to be used for the public. That's in G. Anyway, H, for attorney's fees pursuant to California Code of Civil Procedure 102.1. So for the lawyers' fees to be paid by the defendants. I, for prejudgment and post-judgment interest. So that's the percentage interest. I don't know what the rate is over there. And then J, for such or other further relief as the court may deem just and proper. So that's just in case the court wants to make any other orders. So that's a 46-page complaint, so it's referred to, against OpenAI and its group of companies and some individuals, Altman and Brotman. I'm not taking a view either way on whether there's a basis for the claim. I'm not going to do that. That's for somebody who's I'm here to just provide information and entertainment on a non-liability basis. You've got to do your own research. But what I will say is I've got an interest in technology. So this case came before me, so to speak, and I thought I'd take a look at it and maybe the potential impact this will have on industry and technology moving forward. Say the court does make a declaration that there is AGI. Are there going to be new legislation and cases arising from that? What impact does that have on world politics? Obviously, Mr. Musk said that he's concerned about who technology whose hands that gets into. Maybe this will be like if that AGI is released, will it? Like how you had the industrial age, you had remember in 2000 you had the impact of computers and people being able to do so many different things in advanced industries and stuff. And then now, if AGI is released on a broader level, are we going to see it solving ways? I don't know, maybe around space travel, leaving Earth, interplanetary travel, more inventions. Who knows? The scope is enormous, really. Maybe finding a way of healing diseases that have been, afflicting people for many years. Who knows? The possibilities are probably endless. And as people always say, the state of AGI or artificial, it's at well, I would say it's going to be at the dumbest it's going to ever be, because as we've seen over time, with technology, things just improve and get better. But anyway, this case, the theme running through it is about preserving AGI for public use and protecting the public from nefarious uses of it and preventing it being used for commercial gain at this stage. Anyway, that's what this case seems to be about, and also the fact that he seems to be suggesting that Mr. Musk seems to be suggesting that he'd involved himself to assist this organisation and provided funds, but then he's saying that they've not done what they said they would do. Basically, that's what he's saying. I'm not going to comment on whether that is true or not. I mean, I wasn't there. I'm just here talking about technology, basically. But I'm going to say I'm done talking for now on this. Very, very interesting. So what I'm going to ask you to do, please like, share, and subscribe. Please like, share, and subscribe. Done talking. And the usual disclaimer applies. The information in this report is all alleged or allegedly. You should do your own research. We're not going to be held liable for you relying on any information on this report. We're not claiming anything to be a fact or either way. We're just taking a neutral view on the information that has been read from what's purported to be a complaint in this particular case. Do your own research, and maybe some point we're going to have a press conference from Mr. Musk himself on this. And then also the other thing that I want to stress as well, this is just one-sided, so to speak, because this is just a complaint from Mr. Musk. This is a very elaborate disclaimer, isn't it? But I mean, this is a complaint from Mr. Musk. I haven't heard the response from OpenAI or any of the other defendants, including Mr. Altman. So we should look out to read that as well, just to see, so we can get a balanced view about what's actually happening here. And maybe or maybe not, the court will take a look at this at some point. But anyway, thanks very much for listening. Really appreciate all the listeners, the growing subscribers. We've gone up a bit in subscribers recently, so I really appreciate that. Keep on sharing, liking, and thank you very much. Done talking for now. Yep.